This is Rahul Reddy. We are live here from Houston, Texas. Every Tuesday at 5 p.m. Central Time, we do have live session. We take question and answers for everybody for a period of 1 hour. Emily, what do we have to discuss today?
Yeah, today we wanted to talk a little bit about the EB-5 green card. What is the process? What's the requirement for that? Is that something you should consider as a backup plan with these EB2 and EB3 dates continuing to be backlogged and not moving forward? Also, a major problem people have been experiencing for some time that's continuing, and that is visa interview appointments not being available for a year. It's taking 400 days to get an appointment at some consulates. What can we do about that? Are there any options? We'll discuss that. And we've been seeing some odd situations where people have an EB3 and an EB2 485 pending, so two separate 485s. And USCIS is administratively closing the EB3 485, which is normally not a problem, but they're doing it before they approve the EB2 485. So when the EB2 485 is still pending, what happens to that EAD and AP that were approved with the EB3 485? What if you didn't file one with the EB2 485? Is there any action you need to take there? And lastly, we want to discuss about whether USCIS can revoke an approved H1B. What is the scenario when that happens?
Emily, one thing is that now we know that if it's a regional center investment for the EB-5, the limit after March of 2022 is actually 800,000, which used to be 500,000 before, which is 800,000 though. So can I bring the $800,000 from India and invest in here? Is it okay?
Yeah, you can. What other ways can you get that money?
I can sell the stock price and can invest the $800,000. I can be having a savings of the $800,000 within USA also. I can invest it. So all they are looking is that whether this $800,000 is coming from the legal source of the money. We have to trace it back to your income tax returns. Let's say, for example, if you have a $800,000 saving, where did you got it? I mean, if your family income is $400,000 every year, you have saved up the money and you put some investments, that's perfectly okay. Well, your dad sold an apartment there in India and got our land there in India and gave you the money. Can you put that as an investment to get the green card? Under EB-5, absolutely you can. Now, Emily, with regards to the EB-5, what do they need to do when they go to the regional centers? What do they need to check on those when they want to invest in the $800,000?
Yeah, so
would you help them in identifying which investment is better?
Right. Know that the regional center just means that although USCIS has approved this business to operate as a regional center, it doesn't mean that it's always a good investment. So it's going to be up to you to actually use your investment knowledge and look into that business to decide, is this going to be a good investment? Should I do this? Because just because USCIS authorized them to operate doesn't mean it's the right investment for you. And us as immigration attorneys, we're not able to provide you with any investment advice. We can, do a little bit of research into it, but we can't guide you on which particular regional center to use. So that has to be something that you do based on your investment knowledge, and can't be something that the immigration attorney does.
I'm particularly concerned, Emily, the way the people advertise and people think about USCIS approved means they think so that it's USCIS itself. To tell you an example, let's say, for example, there is a stock and stock market, when you have to go invest in the stock, it's approved by the SEC, Security Exchange Commission. That's the reason it's trading. Does it mean all the stocks are good? No, it's up to you to judge which stock is good or which stock is not good. In the same fashion, when the USCIS is approving these regional centers, there the 800,000 is allowed investment. Otherwise, it's $1,050,000, and there are other restrictions that are there. There are less restrictions on this $800,000. It doesn't mean by itself that it is the best investment. You're going to absolutely get the green card. There are risks involved in it. There are things involved in it. You can look into the EB-5 fraud. Just Google it. There are a lot of companies that have done some fraud. So be very careful on those things. As Emily has pointed out, that she's not a licensed financial broker and can't give advices on the investment. She can only give advice on the immigration aspects of it, though, but not on the investment. You, on the contrary, If you have made $800,000 at this young age, you definitely are a smart person. We rely that you have made the judgment call based on your analysis and what you think is better investment. That would be, we will rely on that information more rather than our advice. So when you consult a lawyer like us, though, we normally will guide you what is the time process involved, and then we'll tell you what does the regional center do, how they will take your money, how they will invest, will be up to them, but we'll just give you the overall guidelines. And based on that, we will start the paperwork for you to file the 485, to file the entire application. Emily, there are a lot of people that are telling that the whole green card can become in 1 year. Is that true?
No, definitely not.
Of course, recently USCIS has made some changes with regards to the EB-5, Emily. They have allowed us to file the I-529, which is equivalent to the I-140 for our folks, and 485 at the same time when the priority dates are current, which are current in now for the EB-5 though. So that definitely has reduced the time for the 485 application. But how much time is it taking for the I-529? I mean, that need to be approved before the green card is approved though. Because a lot of these agencies are telling that, oh, you're going to get the green card in 1 year, and you're telling absolutely not. What do you mean absolutely not?
No, that I-529 processing time is currently 52 and a half months. So if you think your processing time with your I-140 and 485 is bad, this is
very bad.
Very bad.
So don't they have any premium processing, Emily?
No premium processing, and you can't get the green card until this I-529 is approved, and then they adjudicate the 485, which is going to add a little more time.
Maybe 2 to 6 months is average time after the I-529 is approved. I will take that. That will take 52 months, and then after 52 months, it will take about 2 to 6 months to approve the 485 application, assuming that we file I-529 and I-485 at the same time. So does it mean that after I get the green card, that's it? Goodbye to you and goodbye to the regional center?
No.
What do you mean no, Emily?
Yeah.
I mean, I already got my green card. Why do I need you?
Because your green card is not a green card. It's only a conditional green card. So it's only going to be valid for 2 years.
You mean to say I invested $800,000 and I paid you your damn money and you gave me just a green card that's not valid for how long is it valid for?
Just 2 years.
Oh, but is it the same thing with EB3 and EB2 green card though? When we are paying the money to you, is it only valid for 2 years or is it valid forever?
That one's valid forever.
This one is valid for only 2 years.
Yep.
Okay, and then what do I do after that?
So then you have to file another application with USCIS to remove the conditions on your conditional green card in order to get the permanent green card like you would normally get in EB2 and EB3. So you have to wait for 21 months after you receive your green card.
Okay.
And then you can file that application to remove the conditions.
You mean to say I-829, then
Yes.
we file I-829 after 21 months. So wait, 52 months for getting the I-529 application, then approximately 2 to 4 months or 6 months to get the green card. Let's make it 2 months. Maybe I'll get it in 2 months. Then I have to wait for 21 months because the green card is only valid for 24 months. Within 90 days before my green card expires, I can apply for the removal of the condition. And then how long the damn I-829 takes?
That one's 57 months.
50, did you say days or 57 months, Emily?
Months. 57 months.
Wait, so it's 52 months plus 2 months, 54 months plus 21 months, which is 73 months plus 57 is, oh damn, that's like more than 10 years to get the green card, Emily.
Yeah.
So is there any premium processing for any of these things?
Nope.
This is something that most of the people are not aware, guys, that the time process from the scratch all the way to get the permanent green card is 10 years. And that's where people come to our office saying, Rahul, how fast can you get the green card? And then we say, well, it's going to take 10 years. And the first question that you asked, are you a lawyer? Are you an immigration lawyer? Yes, I am an immigration lawyer. We have an immigration lawyer. But we don't do the other side of the immigration where we tell that your green card is going to be achieved in 1 year. I mean, we don't. We can't. And if you want to verify any of the information what we're speaking about, all you need to do is that go to the USCIS website and just check the processing time. Just type in processing time of the USCIS. Remember the form numbers I-512 and the second one is I-829. These are the two form numbers you need to know. And once you type in those things, you will get the processing time. The processing time we told you about is only for non-Chinese nationals, though. Please make a note of that. If it's Chinese national, add 30 months to extra to it. That's approximately 2.5 years extra. Because their date is backlogged a little bit, that's the reason they have to wait for a longer period of time. So normally, if you are waiting for the employment-based green card, though, this may be a good option for you, but you need to have the realistic expectation how long it's going to get it. Put it on the side basis, not that, okay, you're going to get this one. Maybe you'll get the employment-based green card too. But if you have this extra money and then you want to invest, you think so this investment is going to work for you, it probably is a good option for you to choose for. Because the priority date for EB2, we don't know how long it's going to take, especially if you won't get it, the green card by September of 2023. It might take a long time unless something changes. You may want to consider this as a side option too if you see that if you are going to get the green card through that. But picking an investment option, picking a regional center is definitely an important thing because the business has to be there for a long period of time for you to get the eventual green card though. So it is very important that you pick a very right business, probably a real estate business, which normally most of these regional centers are, may be appropriate, but you need to go to those locations. Is San Antonio good for you? Is New York good for you? Is Chicago good for you? Is this particular location good for you? What are the prospects of those things? Don't just go by the words, what they are speaking about, guys. Oh, they're going to promise everything. 1 year, you're going to get everything. Guess what? We see these people traveling in first class. You know, have you ever traveled in first class, Emily? I've never traveled. I once traveled.
I got upgraded once.
That is business class. We got upgraded. I got one time upgraded to business class. It is these people who are going to go in your first class with your money, guys, and they don't care. They might be flying in your jets based on your money. So be careful with these people, though. We leave that judgment call to you. We're not that good investors, believe me. Not that good investors. We are professionals and only one particular category called immigration law, but we are not good in investment advice. We cannot give you investment. We don't have a license to give you investment advice.
Other thing to think about with that is, as you mentioned, this can be a good side option, but don't rely on it for your status. So even though you can file the 485 when the date is current, along with the investment application, and you'll get an EAD and an AP from that in 6 to 8 months, maybe 10 months. But we would not rely on that EAD. We would not rely on that AP.
Advance parole.
You should continue your H-1B status. Keep extending that based on your I-140 while you wait for that date to be current. Because if you're relying on that EAD and AP and the case gets denied, you're immediately out of status unless you've kept up with your H-1B.
And we call that in Hindi, na gar ka na ghat ka. Now, if you recall that previously, when we were always advising people that until your I-140 is approved, never use the EAD. The same principles will come here, guys. Until the I-529 is approved, though, you should not count that your green card is yours. That's a very crucial thing for you, though, because if the I-529 is denied, the entire 485 will be denied. Very similar to the I-140. I-529 is very similar to the I-140. So that's the reason why Emily is pointing out there. Anything else, Emily, before we go to the next topic?
I think we can move on. So next up is the situation with getting visa appointments. I mean, we've been talking about this for, I feel like, 2 years.
We've been talking about it, Emily. While you're talking about it, the Chennai is taking 415 days. New Delhi is taking 390 days. There are no appointments. Paris, which is better but not suitable for us, is 220 days. Hyderabad has been 219, which is very good. But Emily, that's a long period of time for an appointment to be scheduled, though. What are you doing as an effort to reduce it? I mean, telling the people, wait for it? Telling the people, keep on refreshing on there? Or are you doing anything else?
Yeah, at this point, we've given them enough time to fix this situation. I don't want to say COVID is over, because it's obviously not. But businesses, the whole world has pivoted and found a way to operate in COVID times, except for the Department of State. They can't seem to figure it out. They can't seem to figure out how to issue visas when things are closed. And so they've had enough time to figure it out, and they still haven't done it. So at this point, it's time to start using the power of the pen, use your voices to reach out to people who can actually try to help this situation. So number one, on immigrationgirl.com today, I posted a template for a letter that you can write. I need you to send it to 4 different places, though. I want you to send a letter to the Department of State's Bureau of Consular Affairs in Washington, D.C. This one has to be sent on paper, like a real letter, snail mail style, explaining that it is untenable in this situation. They are stopping people from attending marriages, stopping people from attending funerals, from births, from business travel.
Getting married too.
People are stuck here, people are stuck there. And it's just, we've had enough at this point. So you're going to send one letter to the Bureau of Consular Affairs, and then I need you to reach out to your congressperson and to both of your senators for your state. And so I have instructions for how to find your congressperson, how to find your senators. You can do that one through their website. They usually will have a contact me form, and you can cut and paste the letter into that form so that they're getting information to the congressmen, to the senators about what the Department of State is lacking and how they're failing, and put some pressure on them. Because again, this is the same thing we did with USCIS with these employment-based visas going to waste. We've contacted USCIS and we asked our congresspeople and senators to put some pressure on them, and it worked. So we need to do the same thing here. And then last, we do suggest also sending a letter. Again, this one has to be by mail unless you're in her district, to Zoe Lofgren, who is a congresswoman in California who's definitely been an immigration champion for some time and has some sway there as well. So we do highly recommend for you to take a look at that and take action on it. It's time. They've had enough time to fix this situation. It's been months since they've claimed that they don't, have the resources, but how many people have paid the visa application fee to get nothing? What are they doing with all that money? It's time that they fix this problem, and we need you to help us amplify this. It's not enough to be retweeting things on Twitter or signing a petition or asking for them to come up with some new program or new way. I mean, great, yeah, it would be nice if they would do visa revalidation in the U.S. stateside stamping, which they did back 20 years ago. But that's going to require them to do a new process. So we need to just get them to fix the existing process while they work on new advancements.
Pranay was asking the question, can you put a template? We did, Pranay. At the bottom of the video, there's a link provided for it, though. The template is provided. It's in the immigrationgirl.com, which is the blog for Emily. So that template is provided. Please pass this template to, there are a lot of Telegram groups, WhatsApp groups that are been waiting for the visa stamping dates. Those please pass on these things. I don't mind you guys refreshing, that's fine, but I also want you guys to write the letters to these people, so that things can be worked out, because we don't want a bandage. We don't want just only one person, you get it, but what about the rest of it? You may be lucky. You refresh, maybe you got it, but the rest of the people won't. So please write the letters. Even if you are not waiting for the visa stamping, you need to understand the pain that these people go through. You can understand, you're an immigrant, you can understand the pain that you go through. Back in olden days, my age group people, when I speak with them, what visa appointments? We used to get in 2 days. Yeah, now it's 2 years, dummy. They don't understand it. You guys understand it. So even if you're not waiting for the visa stamping, you understand the pain that it goes through. So please have these letters, write these letters. A draft has been provided. Now, there are some cases, guys, as Emily was pointing out, the third topic that we want to cover was that people have filed EB3 and EB2 485 applications, though. Most of them, a good number of them, got their green cards approved. Good for them. Good luck for them. Wish you best of luck until you get the citizenship, which you are going to get the citizenship for sure. But for those people where the EB2 got approved, their EB3 was been administratively closed or denied, which is perfectly all right. Now, there are some people who filed the EB3 and EB2 We have noticed that the USCIS is administratively closing some of the EB3 applications. It may be okay for some people. We are more concerned of the people who have used the EAD though. That's where we are more concerned about. If they are using the EB3 EAD, they don't have the EB2 EAD. We may want you guys to consult a lawyer though. If you have not used any of the EAD and advanced parole, you may be perfectly in good shape. But if you have used the EAD that came along with the EB3 and you don't have an EB2 EAD, it is right time for you to contact the lawyer. We will tell you what are the risks involved in it then to see if you want to do the motion to reopen for the EB3. And then you can make a judgment call at that point of time what you want to do. Anything else, Emily?
No, last we wanted to talk about this idea of revoking an H-1B after it's been approved. Does that happen? Can they do that? They've already approved it. Why would they go back and revoke it?
First of all, the word meaning of revoke, Emily, is that it's been already approved, then they're going to revoke it. Obviously, sometimes where we see that when the employer withdraws it, they use the same word, that the H-1B is revoked. Don't get confused about it, you're fine. If the employer has withdrawn the H-1B application and it's been revoked because of that, you're perfect. What we are speaking is not when the employer is withdrawn, guys. What we are speaking about is when there is something wrong in the application. Especially we do see that when a company files H-1B for mass people whom they are not working, expecting it for them to actually get through their lottery and not get through the employer's lottery, and they file a H-1B. These are people who are not working for the company. They file it expecting. So that's a fraudulent company. They never had any position to file a H-1B. So USCIS, when they look into the stats of how many H-1Bs they filed, how many they filed in the lottery, how many they got selected, how many they actually filed the application, they're able to determine that this company is a fraud company and they normally revoke the H-1Bs. That's one kind of, and that's once that H-1B is revoked, there are a lot of potential dangers, which I will explain. The second kind of companies, Emily, is that they file with in-house projects, which we know what those in-house projects are. They file with the in-house projects, which there are no in-house projects. And I'm not speaking of Facebook, Apple, Google filing in-house projects. They do have in-house projects, that's fine. They're speaking consulting companies working from a Regus office, like a rental PO box, and they file as in-house projects. And later on down the line, 6, 7, 8, 5, 6 years down the line, their H-1B gets revoked at that point of time. Even though the H-1B has already expired, and let's say, for example, if they get a H-1B on 2016, their H-1B expires in 2019, even now they go back and revoke the 2016 H-1B because it's fraudulently filed at that point of time. The problem here is that if the first H-1B gets revoked because of any of the wrongdoing by the employer, though, here is what's going to happen, though. The subsequent H-1B will be revoked too. Why would the subsequent H-1B? Let's say I got a H-1B with ABC Consulting Inc. I moved on to the Apple. Explain to me why the Apple H-1B will be revoked.
Yeah, because that very first one was your cap subject H-1B. When they revoke a cap subject H-1B for something that the employer did wrong, they revoke it as if it never existed. That means you've never actually been counted in the cap. So when Apple filed your transfer later, you're subject to the cap, but you haven't gone through the lottery because that one was revoked. And so they're going to say, you're subject to the cap, you need to go through the lottery, and they go back and revoke all the domino H-1B petitions that happen after that very first one. So it's definitely a dangerous situation to be in. USCIS does have to send a notice of intent to revoke prior to doing the actual revocation. They send that to the company. The company usually has only 30 days to respond to that. And then after that response, if USCIS feels that the grounds have not been overcome, they will revoke that. And then it may come back later to other filings you've done, even if you've left that company years ago.
Can B2 visitor visa be revoked? And this is from Srinivas Bullam. And can we submit an application to revoke B2 visitor's visa? That sounds a little bit odd, what you request. First of all, B2 visitor's visa can be revoked, especially if a person overstays. Let's say, for example, if your mother is coming into United States with a 10-year multiple entry visa, and she's allowed to stay here for 6 months period. If she says 6 months and 2 days afterwards, and then she leaves the country, her passport visa is considered to be automatically revoked. If you stay in this country 1 day more than you're allowed, your passport visa automatically becomes revoked. Second question is, can we submit an application to revoke B2 visiting visa? This comes from Srinivas Pulam again. The question is, what are you speaking? I mean, mainly, is it something like, say, for example, you requested the consulate to issue a visa for your cousin, for example, and now you don't like that cousin anymore and you want to revoke it. No, you cannot revoke it. They must have done something wrong to revoke it. Just because you're a sponsor for the B1, B2 visa, you cannot revoke it. Let's say, for example, your particular company filed a B1 or B1 visa for a particular individual to visit, though. No, the company doesn't have an authority to revoke the B1 visa. They can still independently come without your company help, though. But only in the status violation in where they overstayed, then the visa can be revoked.
Bhaskar says, if I start using my AOS EAD, can I later switch back to the H4 EAD once it is approved? My H4 extension got approved, but my EAD is still waiting, the H4 EAD. So you can't just automatically switch back to the H4 EAD, but it is possible to do through travel. So once you start using your AOS EAD, you're no longer in H4 status. So just going back to the H4 EAD does not put you back in H4 status. You need to exit and enter in H4 status, and then you can use your H4 EAD. So if you have the valid advanced parole, you could travel and come back, use automatic revalidation in Canada or Mexico and come back showing your H4 approval notice, and then you can start back on H4 status from that point going forward.
Emily, I may need some attention in the second part of the question, Emily. This question comes from Murlidhar Gundam. Murlidhar. He is an EB2 and he wants to file an EB1, I'm assuming, and he has some international reportees. That means that he has supervising employees that are outside the country. The first thing for EB1C, Murlidhar, is that you must work for the international company, though. So let's say your company has branch offices in India. If you have never worked for the Indian branch office, you are not eligible for EB1C. That's for sure. Then comes the question, Emily, when we are documenting for EB1C, though. Typically, I say that if you have more than 15 employees reporting to you, you're in a good shape based on the graph. But can all the reportees be outside the country and this guy is in this country?
It doesn't seem like it's possible from a common sense standpoint, but I've not had a problem with that. Knock on wood.
Okay. Okay. Yeah. So if they are international reportees, you definitely have a good chance. Definitely. But as I said to you, Murlidhar, is that you must work for the company outside the country before you're eligible for the EB1C. Go ahead.
Anusha says, my H1B extension was approved for 3 years in September after I got my green card approved in August. Will that have any effect on my green card? No, not at all. It's fine. You already mentioned your lawyer sent a withdrawal notice. Totally fine. Nothing to be done.
Nava Kannam, can 2 or 3 friends together invest 800K for EB5? No. It is for you only, not 800,000 per person, not per group of people, because it's only you they are going to give the green card, not with other people. So the investment has to be from you only.
Yahoo Me says the H4 to H1 change of status was filed in June 2022. I'm assuming that's part of the lottery. When can we expect the approval? So they are processing those. You can actually check the online processing time going to uscis.gov. You can select case status processing, And then you need to know, you'll need to select the form number, which is I-129 for an H-1B, and then you select the service center where your case is pending, and it will tell you how long it's taking for 80% of those cases to be approved. And then it will also tell you if it's considered to be out of normal processing time based on your receipt date. And if it is, then your employer can actually submit an e-request, or your attorney can.
Prashant Kumar, his mother has stayed over 6 months and he did not file the extension at the proper time. What is the best course of action? We would want her to file the passport stamping again. And when they are asked, hey, your passport visa is still valid, she should say that she violated the status, thus by her passport visa is automatically, not violated, overstayed the status, and her passport visa is automatically cancelled, and thus by she requires another visa though. Don't let her come, because we have seen that CBP detaining the people, putting them in the jail in 1 or 2 days and sending back. So don't let her come though. Have her apply for the visa again before she comes in. Since she stayed less than 180 days, I'm assuming after her 6 months expired, she should be fine in getting the visa again. Question from Ravi Kumar, and this comes out a very, very frequent question. I filed my 485 and then I interfiled EB2. I got my EAD. Is my EAD in EB3 or EB2? Here is a question, Ravi Kumar. The EAD is for the adjustment of status though. It is not for EB3 or EB2. We don't know at this point of time whether you are in EB3 or EB2 when you interfiled it. The USCIS will determine whether you are in EB3 or EB2 at a later stage though. But for now, you are in just adjustment of status. At the time of adjudication, it will be EB2 or EB3. So you are free to use EAD, absolutely. Can you switch back to EB3? Yes. Can you switch back to EB2? Can you keep switching every month, EB3 to EB2, EB2 to EB3? Absolutely, you can. After using the EAD, can you do what we discussed about? Absolutely, you can do it.
A couple questions about submitting the medical. I missed the name, but someone, Ramesh, 485 case status updated to request for initial evidence requested. If we know the field office, can we just send the medicals in before we get the RFE? I would not do that. I would wait the few days it's going to take to get the RFE and then send the medicals in response to that, because the RFE has a barcode on it, so it will be easier for the USCIS field office to make sure it gets into the right place. Plus, if you send it in early, USCIS may then assume, if it doesn't make it into your file, that you didn't actually respond to the RFE on time and could just deny your case. So I would wait for the RFE to send that in.
A question from Debashish Paul, and this question is about the location of his I-140 is approved for, let's say, for example, Florida. I'm going to dramatize it a little bit, Mr. Debashish. He has a labor approved in Florida. Now he's moving to California. He might visit Florida for the work location once in a while. Now the question is that good enough for him, or does he need to file another permanent I-140? There are two things here, Debashish. If it's a consulting company, and they have put the provisions that you could be working at multiple locations or different locations, you absolutely don't have any problem at all. Now, if it's not a consulting company also, there are many exceptions though. The question is that if you move to California though, where is the future job after you get the green card? If the company thinks that the future job is in Florida and you agree with that thing, even though you never, ever, ever step in Florida, you're always in California, you do not need to file another labor and you do not need to file another I-140 though. But when the question mainly comes is that, is the company is going to be cooperative on that? Is the company flexible on that particular statement that your future job is in Florida? And if they are not flexible, then it's a different issue though. Normally the companies like FAN companies, most of those companies, though not all, but most of those companies, they're pretty flexible in that. Sometimes they actually ask you to write a document and give it to them that once you get the green card, you will move to Florida. That's what they say. And then people come and question, after they get the green card, what if you don't move? Well, it's a promise that you told that you will move, but just like the New Year promises, if you break the promises, which I know the business you do break your New Year promises, there's not going to be much penalty. There's not going to be any penalty at all. It's just a promise. Sometimes people break promises, but that's not a fatal thing for your green card or for you getting citizenship or canceling your green card.
Pradeep says, if I work for multiple employers with the GC EAD, do both of the employers need to file a 485J supplement? No, they don't. So just the employer that is forming the basis of your 485. So let's say you have your 485 pending based on company A, and you're going to now work for company A and company B. Well, nothing needs to be done because company A already submitted the supplement J, or they filed along with the I-140, so it wasn't required. But let's say you worked for company A, filed the 485 with A, and now you're moving to B and C, and B has the similar job that qualifies for AC-21, and C is just a side gig. B is the one that would need to submit the supplement J to show that you qualify for AC-21. C does not have to submit anything.
Question about Sandeep Viraparthi from YouTube. Is a 60-day grace period after job loss on H1B, is it cumulative? That means that if it's 4 employers, he loses a job, or is it every instance though? The answer is simply every instance though. But please make sure the 60-day grace period is only available when the validity of the I-94 is there. Let's say, for example, the company A's I-94 is expiring in June of 2023, and you lost the job right now. You have a 60-day grace period. Then, let's say, for example, somewhere in November of first week, you get a new job with a different company, and you're going to get H1B from November of 2022 to November of 2025. Somewhere in 2024, you lose a job, you get one more 60 days. But the I-94 of the company B must be existing in that particular 60 days. If the I-94 doesn't exist, then the validity of the I-94 doesn't exist. The 60-day does not exist. But to answer your question, it's every instant, not cumulative.
Shilpa says the H-1B was denied, referring to an incorrect degree certificate. Should I file an MTR, and how long will it take? Well, the MTR typically is taking at least 6 to 8 months, so it's definitely not a fast process. Whether one should be filed really depends on the merits of the case. I mean, if, for example, if for an H-1B we know it has to be a position that requires a bachelor's degree and you only have an associate's degree, well, there's no way that MTR is going to be successful, so it doesn't do you much good to file that. But maybe there's some confusion. Maybe the job normally requires a computer science degree and they denied because you have an MIS degree and didn't feel that it was related. Well, maybe you can get an expert opinion letter that explains how that MIS degree is related to computer science and therefore qualifies for the job. And then maybe an MTR is a good idea. So it really depends on the merits of the case.
Question, Satish, just to follow up the EB1C, he has 40 employees that are reporting and a high salary. Yummy, that's nice. Eligible for EB1A. Now, EB1A qualifications are quite different though. It's not the amount of employees. Your high salary may actually be a factor in the EB1A. But that you are supervising 40 may not be a factor for EB1A though. You may want to watch a YouTube we made about 1 week ago on EB1A, especially on EB1A only. You may want to watch that video to get a clear guidelines on EB1A. EB1C requirements are that you must be supervising more number of employees, but when it comes to the EB1A, that may not be that significant enough.
Krishna says, if I get married in India and my wife applies for an H4 and is waiting for the interview or Dropbox slots, is it possible for me to add her to the 485 application? No. So in order to add her to the 485 application, she has to be physically in the U.S. and your priority date has to still be current. So if she's outside the U.S., you cannot add her. There's no way to file a 485 for someone who's outside the U.S. You may be able to process a follow to join application so that when your green card is approved, she can then proceed to get the green card through the consulate. but not the adjustment of status process.
A lot of questions on EAD use and advanced parole use, and especially from SK. You need to think about it, guys. I mean, it may take a little bit time for you to digest because we don't know how long you'll be staying in adjustment of status, though. Probably by the end of this year, end of next year, which is September 30th of 2023, you'll get a clear guidelines to see how the priority dates are moving, though. Until the final action dates are current, your green card will not be issued, guys. That is the truth. Even if the filing dates move, you won't get the green card. The final action date has to move. So a lot of people ask the question, should I move on to the EAD? Should I continue on the H1B? There are some advantages on moving on to EAD. There are very less advantages, but yes, there are some rare cases where you may want to consider maintaining the H1B. It may be worth for you to have a consultation independently, though. A lot of lawyers, when a lot of people that I speak with say, no, everybody I speak with them said that you have to maintain the H1B and USCIS. Not everybody. I don't. A lot of good lawyers don't. You need to understand that it's very expensive to maintain the H1B. In fact, today we got an H1B revoked for overpayment of the salary in one of the case. And actually, because of the H1B revocation, it is affecting her green card application too. May affect her green card application too. So it's not that it's always advantageous to have two applications, and then it's not always advantageous that you keep pumping the money to the immigration lawyer. No, there are some harmful effects too, though. And people don't realize that thing. There's a lot more flexibility, lot more flexibility on EAD than compared to the H1B. So people need to be careful, and to spend all that money and to go through every time, not your money. I mean, your company is, you have to value your company's money as your money. I mean, they are paying you the salary. They're treating you very good. Their money is your money too. You don't want them to unnecessarily spend the money. Yes, there are some times if you're EB3, you're an EB3, you want to get an EB2. That's something you need to spend. I think so. It's valuable money, but maintaining H1B, I don't think so unless you have some specific reasons, though. So please disregard some of the people who are advising you just to get maintain the H1B, especially the lawyers. They just want to make money. I mean, if you're in H1B, we make money, guys. We make more money because you maintain H1B, you maintain I-1, you maintain the EAD, you maintain the advanced parole. It's more money for us. So we have more incentives to tell that maintain the H1B. So please be careful on these things.
Infund says, if the 485J is approved this week for EB2, does it mean a visa number has been assigned to the 485? No, it does not. We just got some documentation from USCIS through some litigation. They made it very clear that assigning the visa number, the term they used, it's the penultimate. It's the very last final thing they do before they hit approve on the 485. So generally, most people are not assigned a visa number until the very end, right before they're ready to approve the 485.
Nova has this question that he has filed an EAD and advanced parole, and his EAD got approved, but his advanced parole is pending. Now the advanced parole is saying fingerprints have been taken. Is there any way to expedite it? You can contact the USCIS office, and if there is a genuine reason to expedite, for example, if your parents are, somebody's sick there, and you can provide the medical documentation, though, that may be that they will expedite. When they give an expedited advanced parole, they may only give you for 2 or 3 months, guys. They may not give you for the entire 2-year period which you are eligible for.
Siva says he worked for 3 years on H1B, went back to India for 2 years, and then came back to the U.S. in 2022. And his employer is saying that the H1B 6-year limit has reset, and he has 6 years of H1B. Is that correct? No, it is not. You only have the remainder of your time, which is the 3 years. The only way that the 6-year limit resets is if, number one, you're outside the U.S. for 1 year and you go through the lottery again. So you either use the remainder option with no lottery and you get whatever's left, or you use the new 6 years and go through the lottery. It's one or the other. So no, you don't have the fresh 6 years simply because you stayed out for 1 year.
one of the question is that can we do international travel while the H4 EAD application is in process? If only H4 EAD application in the process, absolutely no problem. EAD will still be approved.
ISWG says the principal 485 is approved, but the dependent's case status has been updated to case remains pending. What will happen? Yeah, it's surprising to see how many people they've separated the family members and approved the main applicant, but not the dependents. We've seen that quite often. So they won't be able to approve the dependents if the priority date is no longer current. Those applications will just remain pending. They'll be able to keep getting the EAD and AP renewed until the final action date becomes current again, and then USCIS can adjudicate that. Other option is potentially to proceed in the family-based category of F2A by filing an application on your dependent's behalf as a spouse of a green card holder. We do have a special video on just that topic. If you check that on YouTube, search for, I think we put it under F2A, you'll get the details of that.
Madan's priority date is, filing date is current. Could it be that next fiscal year it will be final action date will be current? Yeah, very good chance, because you're only 30 days behind. So definitely very good chance that the final action date will be current next year, which is starting from October to September 30th of 2023. Question from Sai Kiran that his I-140 got approved from his ex-employer after 1 month. I moved to a different employer. Is it really necessary to stay for the 6 months for the employer to have the I-140 validity? It doesn't matter whether you have stayed with the company for a period of 6 months or you did not. What matters, Sai, is that when did they withdraw the I-140? Did they withdraw it after 180 days or before 180 days after it's been approved? So even though if you leave the company, if they did not withdraw for 180 days, that I-140 is yours.
Sachin says, can we travel internationally while an H4 EAD application is in process? So it depends. If you mean just the H4 EAD itself, the I-765 application, yes, and this is assuming that you have valid H4 status and a valid visa to come back on, and you've just filed the EAD by itself. You can travel while an EAD is pending, but if you filed an I-539 extension and an H4 EAD extension, and you're waiting for that H4 to be approved as well, if you travel, you're going to need to get the H4 visa stamp in order to come back, unless you qualify for automatic revalidation and are just planning on traveling to Canada or Mexico.
Question from Shilpi Kapoor. She got an RFE for a birth certificate, which we are seeing very frequently, unlike before. She filed 2 birth affidavits. Her parents are not there, submitted a 4th affidavit. Shilpi, you want to get a non-availability certificate from where you're born at. That's one thing that I want you to get it though. Any place where you're born in, you can get the non-availability certificate. If you cannot though, you need to do all your best efforts. Hire a lawyer there, do something there to get the non-availability certificate. That's the first thing that you need to get it. Other than that, I also would like to submit as many documentation as possible, Shilpi. One of the things I would suggest you is that if you have an Aadhaar card, PAN card, election card, ration card, school certificates, any of those things which have any government records that have election card too, any government records that has, sometimes they may not have your entire birth date. It may have your dad's name, mom's name, your year, how many years you are on that particular time though. All those things are in evidence though. But the main thing should be is that you need to get the non-availability certificate. They're very strict nowadays on those things though.
Regina says, I'm currently working on H4 EAD, but have an AOS EAD. If I return to the US using AP, do I have to let my employer know to use the AOS EAD? No, so your employer only has to obtain updated employment authorization documents from you when your EAD is actually expiring. So for when that happens, then they have to re-verify your I-9. And at that point, then you provide whichever EAD or work authorization you're using at that time. But you don't have to update it in between if the EAD has not expired.
Question from Travel from Santa. Are the GC quota over for this year from EB1, EB2, EB3? They definitely are over. We are seeing some trickling approvals, like one or so. Very rarely, a couple of them are coming in, but these are all, they're already assigned before September 6th or on September 6th. It's not like they're approving it because when the USCIS officers are going into their database, they go there and when you go for the interview, or they go to a different place though, because there are not many computers that directly communicate with the Department of State where the visa numbers are. They go there and they say, no, we don't have, there's nothing putting out there. So there are no visa numbers. It's only if the visa numbers are already allocated. And then comes the question, is my visa number allocated? How can I know that my visa number is allocated? Most probably, guys, there is no way we can know. And most probably, if you have not got the green card, your visa number is not allocated. You have to assume that, though. I mean, I like to keep the hopes on, but hey, guys, we are on September 27th, so it's not there.
Cyram says, do I need to get a new H-1B visa stamp if I change the job? I have a valid stamp until next year. No, you don't. So the H-1B stamp remains valid until it expires unless it gets revoked for some reason. So you can use the old employer's visa stamp that has not expired to enter with the new employer's approval notice and be given the I-94 to match the new employer's approval notice. No need to get a new stamp.
Please, is asking the question from YouTube. Is there a chance I can take my green card back? Well, there's always a chance. 1 in 100 chance, especially for Indian guys who are working professionally in the IT field. It's very rare. The main thing why they take the green card is any criminal activities, guys. That's one thing that can happen. If there is any criminal activity, I'm not speaking of speeding tickets, guys. I'm not speaking of speeding tickets, but if there is a criminal activity other than speeding tickets, though, you definitely need to contact a lawyer. Other than speeding tickets, you should contact an immigration lawyer. Then we will evaluate based on the crimes. There are crimes all the way ranging from DUI to all the way to murder. So definitely, if you murder somebody, your green card will be taken off. If you have a DUI, I definitely still want you to contact a lawyer, but they are not going to take the green card for the first DUI. There are things, so other than traffic tickets, it's definitely worth contacting.
Vineet says, does a valid H4 EAD get revoked? If someone joins a new company and didn't file the EAD extension along with the transfer, what happens if the previous company revoked the H-1B petition? No, it does not get revoked. So that H4 EAD remains valid until it expires as long as the H-1B spouse is maintaining H-1 status and the H-4 holder is maintaining H-4 status. So you're not necessarily required to file it every time you file a transfer. And you can rely on the same EAD. It doesn't get revoked simply because the prior employer withdrew an H-1B.
What is I-485 initial review means? Are they adjudicating the case? My priority date is 2014, October, EB3. They definitely are not adjudicating right now, Chris. They are not adjudicating. Initial review means they are working on your file. That's all it is. It doesn't say that they are going to give you the green card. They cannot give you the green card, Chris, right now. You will have to wait for the final action date to become current. Now, some people ask the question, can I be interviewed even if my final action date is not current? Yes, you could be interviewed. Can I get an EAD and advance parole when my final action date or not even filing date is current? Absolutely. You're entitled for an EAD, you're entitled for an advance parole. Even though your priority date is not current, you can.
Number of questions about getting the H-1 visa stamp in another country. For example, getting it in Singapore for an Indian citizen or Canada or Mexico. So as long as you can legally, physically get to that other country, you can apply for a visa in that other country. It's called Third Country National Processing, or TCN. The problem is during COVID, most consulates shut down, and then as they were restarting up. They had limited resources and they were only giving appointments to their own citizens and residents, and people that were from other countries were not being allowed to apply. I think that is slowly lifting, but there's a chance they could always come back and say, no, we're only going to entertain our own citizens right now if there are certain situations in their country.
Question come from MAPA Nature Lover. My POM approval got today. Is there a hopes I can get the GC before 2036? Because that's when my US-born kid become 21. If I have to go with the existing law, if I have to go with the existing circumstances, pre-COVID, let's say it's pre-COVID. If I go with the pre-COVID circumstances, that they're going to be prevailing pre-COVID circumstances, though, I don't think so you have a chance to get the green card by 2036, though. Why I would say that? Well, I'm assuming that you're Indian. There are a lot of assumptions that I have gone through. I'm assuming that the demand for the rest of the world will be the same. I'm assuming there will not be any COVID. I am assuming that there is not going to be any change in the law, or it could be COVID, it could no pandemics are there, okay? When I say COVID, pandemics are not there. Definitely it's going to take a long time if your POM got it, because when you look into the numbers though, Indians can only be allocated 2,800 green cards under EB2 and 2,800 under EB3 though. So 2,800 under EB2 and EB3, the amount of people who get the H1Bs every year is approximately around 50 to 60, including the university H1Bs. And plus we have L1s, L2s who are also eligible for EB2 and EB3. So you condense the 60,000, even if 50% of the people don't apply, only 30,000 of the people will apply. This 2,800 includes a dependent. So 3,000 for both. I mean, 2,800 is 5,600 for both. So that's each year is a cumulative of 10 years though. So that's very unlikely that you're going to get the green card by 2036. So that's the reason I want you guys to prepare and yourself that it may take a long time for you to get the green card. Yeah, your child who's going to be 21 and 2036 would be a good hope for it. That's the reason why we request everybody that we need a change. The media attention is only on the undocumented aliens and undocumented people in this country. For the people who are working, for this gentleman, nature lover, he's working, he's paying taxes, he's abiding every law that exists in the United States though. He has to wait for 20 years for him to get the green card though. So definitely that's a bad thing. We do not want family members to be counted towards the green card though. We have put a link at the bottom though, because if they don't count the family members, here is what's going to happen with you, nature lover. Within 4 to 5 years, definitely your priority date will be correct if they stop counting the family members. While the parliament or the Congress we call in the United States is doing nothing, the administration can unilaterally not stop counting the family members. The green card numbers will go from 140,000 to more than 300,000 every year. So there will be a drastic movement of the priority dates if they don't count it. From next week onwards, if you keep writing, if you have written letters to the congressman that we have given there, or to the USCIS that we have given there though, then we will respond to you much better. Next week, we expect that you write a letter to the USCIS, not counting the family members, then we will give you much better response. We'll answer your question. We'll give you preference questions. So next week, when you come to the live show, please mention that you wrote the letter, then we'll give you a preference in answering the questions.
All right, well, I think we're out of time for today. Thank you so much for joining us. We will be back next week on Tuesday at 5 o'clock Central Time to give you the latest updates and answer your questions.
Thank you very much.